sometimes he said versus she said disputes in what actually happened leading up to somebody's termination. In that meeting with the HR director, did the person really resign, or were they affirmatively terminated by the employer? I had another instance where the gentleman worked as a driver for his company. He received an OUI summons, or he was arrested for OUI over the weekend. He knew that that was going to mean he couldn't work as a driver for his employer while his license was suspended. So he went in, turned in his uniform, said, gee, I'm sorry, I can't do this anymore. The policy was the company would have terminated him. So he just sort of beat the company to the punch. And in my particular case, the hearing officer found that he didn't voluntarily resign, but he denied him benefits for other reasons, primarily relating to misconduct. But what's important for me to try to convey to you now is it's not always clear whether somebody resigned, even if they say, I resign. So again, though that issue, along with misconduct, is what you need to focus on when you're getting ready for your appeal. And there are resources available to you on the web. If you do a search for the standard of misconduct, you will likely find many cases and decisions relating to how a hearing officer has construed that term. I don't know if the VLP website has any materials on the standard of misconduct or voluntary resignation.
I think there's a link to the Department of Labor, and I think those statutes are on the Department of Labor's website.
So again, you shouldn't, just because you think, oh gosh, they're going to say I resign, you shouldn't give up. The job that you need to remember is you've got to tell the hearing officer what happened and why you believe that it wasn't a voluntary resignation. Because there may be factors that militate in your favor that you wouldn't necessarily have thought of. Well, let me just finish the process. The hearing officer then issues a decision. As I said before, if that is adverse to you, in other words, they decide that you are not entitled to benefits, you can appeal that to a 3-member commission. I am happy to answer any questions. We have some representatives from the Volunteer Lawyers Project here, or if there are any that come from one of the other locations, I'm happy to respond to them. And we see a gentleman who's been, so are you with the library in your hometown? Okay, all right, thank you. Did you want to raise any questions?
Yes, I wanted to raise one question. When you talked about that most of the hearings are by telephone, and then there are some exceptions to that, and that would be in person. Is there any reason why they might decide that an in-person hearing is necessary, or is it just?
You know, I assume there is, but the question is why are some hearings in person versus on the phone? And is there a factor, or are there factors that the Bureau or the Department of Administrative Hearings considers in scheduling something for in-person versus on the phone? And I don't know the answer to that question. For whatever reason, most of the cases that I deal with in the greater Portland area seem to be on the phone, whereas my in-person hearings tend to occur in Lewiston. But again, I don't know the reason for that. And these were not situations where we needed an interpreter, for example, where there were a lot of exhibits. So probably somebody from the division would be able to help us out on that question. In terms of how the hearings are conducted, as I said, they're not bound by the rules of evidence. So hearsay can come in. In other words, you can testify that John Smith said this. Now, the hearing officer, if there's a lot of that type of evidence introduced, may say to you, look, I'll consider this evidence, but it'd be a lot better if you had John Smith come in and testify rather than you trying to recount what he said. That goes to the weight that the hearing officer places on the evidence, i.e. how much they're going to consider it versus it not being admitted in the first place. So virtually all the evidence will come in, but the hearing officer certainly does have discretion if you're offering testimony that does not appear relevant at all to the issues in the case. the hearing officer will ask you why you're trying to introduce this evidence. And if he or she is not convinced that it has relevance, they may instruct you not to introduce it. In that scenario, if you feel like it's really important, you should say, with all due respect, this is why I'm trying to introduce it, and if you allow me to introduce this evidence, this is a summary of what it would be. That's a way to preserve the issue, if you will, for an appeal. One of my colleagues stated that after the hearing officer explained what the administrative exhibits were, those would have been the deputy's decision and the notice of hearing. The hearing officer then explained what the employer's exhibits were, and then jumped into the hearing without giving the employee the opportunity to introduce exhibits. So you have to be respectful of the process, but if you feel that you're not being given the chance to introduce your evidence, you need to speak up and you need to ask questions. And so at that point you might say, pardon me, hearing officer Jones, but I've got 5 exhibits I would also like to have introduced. Because if you don't speak up, if you don't ask questions, then it's going to be awfully difficult later on to argue that somehow the hearing officer did something wrong. Because that's when you appeal the hearing officer's decision, you're trying to point out where he or she may have made a mistake, not only in how they viewed the evidence, but whether they allowed it into the proceeding in the first place. So, are there any other questions?
Getting back to the personnel file, I know from experience that probably the employer might respond better to an attorney's letter requesting a copy of the personnel file. But I've had many clients that say that they've requested it, they've been ignored, and telephone calls, and then I explain the formal letter to the employer, and still they receive delays, even though I think they're required to submit it within a week.
That's right. The question is, what if your employer doesn't respond promptly within a week to your request for the personnel file? I would do a couple of things. I would certainly make sure your request is in writing, so you have documentation of that. If you get to the hearing and you haven't received the file, I would introduce your letters as exhibits to the hearing officer. But if you have enough time, I would contact the Division of Administrative Hearings and say, I want a subpoena served on the employer compelling them to produce my personnel file. And that ought to do the trick. So there are steps you can take. Again, it's really important when the issue is misconduct or even involuntary versus voluntary termination. If you've been a good employee with a good track record and you made that one mistake, you have a much better shot at arguing that that shouldn't be misconduct because of your history of exemplary behavior and employment for this particular employer. Especially if you've been there for a while. We have a number of individuals who have a 5-10-year history, and then they're let go. And if you've got a 5 or 10-year history of compliance with all the policies, and you're let go for the first infraction, that's going to weigh heavily in your favor. And one way to support your claim that there have been no issues is to get that personnel file.
And what if your employment status changes and you're receiving benefits?
And that's an issue that the question is, what if your employment status changes while you're receiving benefits? That's an issue that I don't typically get involved in, but my understanding is you need to report on a weekly basis what your employment status is. And definitely, if things change, you need to make sure, and I believe it's through the website,
yes,
that you report that to the Department of Labor, because that will affect what benefits you receive. And if you fail to do that, then you might be facing down the line a claim for overpayment, and that could be in the thousands of dollars because you shouldn't have received those benefits in the first place. So you want to make sure you stay on top of that you report that immediately. Is that your...
That's been my experience,
yeah.
Yes. Another thing I think we should point out is the website that you want to go to for any type of information through the Volunteer Lawyers Project. It's actually a Pine Tree Legal website. So it would be www.ptla.org, and you would put in the search field unemployment, and there it will bring you to our unemployment page, and information with not only the Department of Labor, but what information that Pine Tree Legal and the Volunteer Lawyers Project provides.
Is that all being picked up, do you suppose?
He was nodding.
Oh, did you hear that, sir? The information that, okay. Just one last issue that does come up a fair bit is when the claimant fails to attend a hearing. They've gotten the adverse decision from the deputy. They file a timely appeal within 15 days from the date of mailing. They get the notice of hearing that says you need to appear at this hearing either in person or by phone on, say, January 15th, but then they fail to show. As a general rule, if you fail to show up at your hearing, you're going to be denied benefits, and that's likely the end of the road for you. However, if there is good cause for your reason not to attend that hearing, you may get excused, and you may get a second chance, if you will, to have a hearing. Good cause are the things that you would normally think of: an illness, an accident, a serious illness of your child, etc. The key is, though, not to just rely on that, but to then take reasonable steps to notify the Division of Administrative Hearings that you can't attend. And the best way to do that is in writing, but also follow up with a phone call, get the name of the person you spoke to. I've had that issue come up. Well, who'd you speak to? And the individual says, well, I don't know. It was some lady at the division. It's really good if you know who it was and you have a letter that you've mailed, and if it's on the hearings in 3 hours, fax it and keep a record of your fax. The folks at the division are going to be very helpful to you. They're going to tell you to fax it or mail it, but you just need to make sure you take those steps. Because if there's anything murky about your efforts to inform the division that you can't attend, if it's not clear that you actually took those steps, you could get denied benefits in your appeal. And I had that happen to me, and we had to go to the commission to the next step and have another hearing. And you hate to have to go through all of that if you could have avoided the problem in the first place by a phone call and a written request. So, are there any other questions?
What about the case of where the employer fails to appear?
Well, it depends on who's appealing. In other words, I've never had that happen, though sometimes the employee appeals and the employer never really intended to contest the employee's entitlement to benefits in the first place, so they're just not even going to show up. And so my experience has been that the hearing proceeds without the employer representative. And you put in the evidence and you get a decision, and typically it's in the employee's favor. I mean, usually there's a good reason why the employer decides not to appear. But if the employer is the one that appealed and then they fail to show, there's no hearing. Their appeal is essentially dismissed.
Do items in the personnel file have to be signed by the employee also, or can the employer just put items in the personnel file?
The question is, can the employer just put whatever in the personnel file, or do they need to be signed by the employee? What actually goes into a personnel file is sometimes a complicated question that people in my law firm advise our clients with all the time. But no, the employee doesn't have to sign something to necessarily make it part of the personnel file. Typically, if it's a performance review or some sort of disciplinary action, the employers do have the employee sign it, not to agree with the contents, but just to acknowledge that they've been presented with this review and that they acknowledge having read it. But sometimes in the personnel file, you won't have the personnel policy. And it may be that what's in the policy is very important to the case, because the issue is, did the employee comply with the policy? And so in addition to requesting the personnel file, you may also ask for a copy of their employee manual or policy. For example, what's the employee supposed to do when they know they're going to be late? If the employer comes in and says, well, he violated our policy because he never called us up 3 days in a row, well, I want to know, does it say that in the policy? So if the issue is compliance with the employer's policy as the employee, you may want to request a copy. And typically in the personnel file, assuming there is an employment manual, the employee would have signed a piece of paper saying that he or she had read it or received it. So it's a reasonable request to ask for